May it please the court, Don Shanahan, Deputy City Attorney, representing the appellant Jonathan McCarthy. This case involves an officer-involved shooting resulting in the death of the suspect. The question before the court is whether or not the district court's order denying summary judgment based upon qualified immunity should be overturned, and more specifically, the court relied on Cruz versus City of Anaheim, and whether the court applied the applicable standards. In Cruz, the court found that when there's a sole survivors, the police officers.
Now, the plaintiffs proffered an expert, Mr. Turvey.
Correct.
And Mr. Turvey provided the court with an account of the shooting. In contrast to Mr. McCarthy's testimony, the plaintiff, the expert, had the distance as 3 to 4 feet. The expert proffered that Mr. Ortega could not have been reaching for Mr. McCarthy's pistol, and basically said that Mr. Ortega was below Mr. McCarthy, was shot in the back of the neck, and was shot while he kneeled or bowed. Do you accept those facts for purposes of this argument?
I accept the fact that he was 3 to 4 feet away. I accept the fact that he was...
Well, do you accept, more general, do you accept Mr. Turvey's account of the way the shooting occurred?
Correct. For purposes of this argument.
You do?
Yes.
Well, there goes qualified immunity.
Well, Your Honor, I don't think so, because if the dispute is whether or not he, as McCarthy says, he was 1 to 2 feet away when he was reaching, or 2 to 4 feet away, that's really immaterial. He's still a threat. The question is whether or not Mr. Ortega was coming at him with his arms reached, and the fact that he might have been 4 feet away doesn't make him any less of a danger. In fact, our expert, Mr. Lewinsky, who's a behaviorist expert, testified, or at least submitted a report, that a average individual can traverse 3 feet in a third of a second.
But counsel, the trajectories, the wound paths are more difficult for you to explain. It's a more serious inconsistency. So I'm looking at 3 ER 362, which shows these trajectories, and I think that your version of these would be that the wound to the abdomen must have come first, because then it's angled
right.
Front to back down, and then as the decedent leaned or perhaps collapsed forward, he was then in a position to be shot in the back of the
right.
neck, so that trajectory could go, as you know, it did from the back of the neck towards the chest,
right.
towards the front of the chest. Correct, so it's possible certainly to get that lined up so that it lines up, I think, roughly with the officer's testimony. But the officers accept that the officer's testimony is that he shot when they were both back up, and so the victim was not below him, and that he shot when the victim was level with him. And I can't reconcile that with this wound trajectory.
I think his testimony was that when the officer got up and the defendant started to reach up towards him, was coming towards him, and then he shot.
He uses the word level with him. So that seems to be getting back to Cruz, that seemed to be a more compelling inconsistency that's difficult. But let's move on to the next one if we could, because I want to make sure you have an opportunity to answer. The other ones that concern me are the ear witness and eyewitness testimony. The ear witness saying that the victim was not shouting, said, "Are you kidding me?" But he sounded compliant. And the eyewitness testimony who turned away after watching most of the altercation because she thought that the victim had been subdued. She thought the action was over. What about that?
I would, yes, Your Honor. With respect to, "Are you kidding me? I'll sue you," Well, first of all, the witness didn't see any of this. He just heard it.
Right, that's the ear witness testimony.
correct.
Yeah, that's what I said.
And the statement itself, are you kidding me, I'll sue you, are not compliant statements, just the statements themselves.
Okay.
So I would suggest that that does not comport with the witness's testimony. Secondly, the witness would be basically testifying as to the state of mind of Mr. Ortega.
But what about the sound of the voice sounding compliant, whatever that means?
I
That's what we've got in the record.
That's correct. It's not.
So he'd given up.
Well, but that's a subjective a term by the witness.
Well, it's what we have, counsel.
But the witness can't talk about the state of mind of what Mr. Ortega was doing at that time.
No, but if I put the ear witness and the eyewitness together, both of them seem to make it sound like, or be, at least certainly be consistent, and we have to construe all these facts in the light most favorable, that the witness is saying, she said she turned away because it was over. She thought the victim had been subdued.
Well, I think what she said was she turned away because she was going to go out to the front door and look and get a better view. She didn't turn away because she thought it was over.
No, but she thought it was over.
But what she said, and if I might have a second, Your Honor, I'll try and get the.
Sure.
What she said was, right before she turned, and then I see the officer have a slight advantage. I'm peering through the blinds, and I take my fingers away, and then the blinds close, and then she hears that, or sees that. But what she said was, he had a slight advantage, and it looks like the officer was going to detain him and handcuff him. He did not believe that it was she thought he had the upper hand, but they were
Right.
still fighting when she left the.
Well, why isn't qualified immunity denied on the basis of McCarthy's various statements alone? He couldn't get his story straight.
Well,
He tells one person something this time, next time when he's macked up, he changes his story. He tells Karsh one thing, he tells another version in his deposition, he tells Sergeant Howie something else. Why are we here?
Well, the reference to Karsh was whether or not the weapon was picked up and pointed towards him. Karsh readily admits McCarthy denies that he ever said that. Karsh readily admits that he assumed the weapon was picked up.
This is what juries are for.
Well,
This isn't simply a series of controverted statements as between the plaintiffs and the defendants. These are the police officers who can't get their stories straight.
Well,
What am I missing?
well, Your Honor, what I'm trying to say is that McCarthy never made that statement. Karsh stated that he did, and Karsh later on said, I assumed he picked up the weapon because they said they had a struggle from his years of experience in dealing with these kinds of situations. Normally, when there's a struggle over the gun, there's a seizure of it. And what McCarthy said.
Let me tell you exactly what he says. Let's deal with what he says. Karsh told the homicide team, quote, "At some point during the fight, Arthur McCarthy's spare weapon that's on his ankle and an ankle holster was dislodged. It fell to the ground. The suspect saw this, picked up the gun, and raised it toward Officer McCarthy." That's what he said.
That's what Karsh said.
Yeah.
Yes. And as I said, when he was
Is
deposed.
that a true statement or a false statement?
It's not a correct statement. That was his interpretation of what McCarthy told
It doesn't have. It's not qualified. It doesn't say, "in my opinion," or "I believe," or
No, I understand
to the
that.
best of my recollection. This is a definitive statement of what happened, and it's not. It's not in a deposition. It's not to an opposing counsel. It's to another police officer.
But again, that's Karsh. And what we're going to end up is actually.
It's not just Karsh. He's an officer in the police department. He's one of McCarthy's supervisors. It's not some guy off the street.
I understand that, Your Honor.
So you think your best day is that Karsh misunderstood or made an assumption and said something that was just wrong, right? But that he didn't have any personal observations?
That's correct.
Okay. But what about McCarthy himself? He told this story differently, and I don't mean anything pejorative by using the word story, but the sequence of events, he related it differently, counsel. And the way he related it was troubling to the district court because the district court couldn't figure out how he had enough hands to do all the things at once that he was doing. The taser, you know what I'm referring to. Right. What about that? It just seems the district court thought not possible a person could have, that the sequence could have played out the way Mr. McCarthy described it. What about that?
Well, he took one paragraph from the entire interview. What happened when McCarthy was interviewed, he was describing in a general sense what happened. And during that paragraph, he never said, well, I put my taser back. Later on, in fact, the next paragraph, if you follow the next paragraph, he goes through it again in more details. Basically what he says, I had him on the ground, I took out my taser, I got his left hand behind his back, I put my taser away, started to get the right hand behind his back, and then
at some point handcuffed him, I think.
Well, he had the left hand.
Okay.
Left hand. He didn't
There's a
get
lot going on.
Well, but that's possible as long as the taser's back in his pocket, and that's what he described in the very next paragraphs.
But he's also reaching out and batting away the other gun that had become dislodged.
But he doesn't have the taser in his hand. What happened is he had his left hand, that is Ortega's left hand, confined.
Okay. Behind his back. He's on his stomach.
He's on his stomach.
Okay.
He was able to, McCarthy with his right hand was able to get his right hand back. McCarthy pulls away with his right hand, and McCarthy looks over and sees the revolver on the ground, and he slaps Ortega's hand away. So, I mean, certainly he had hands enough to do that.
He slapped his hand away. But see, that's another inconsistency. At one point he said he didn't think that it had even been seen, that the gun had been seen.
Well, during the process, during the initial fight, he didn't think Ortega saw the weapon. But as soon as Ortega got his right hand away, he slapped the weapon away. In other words, you have to go in sequence. The revolver falls out. They go to the ground. At that point, he said he's hoping Ortega didn't see the weapon. Once he has his left hand behind his back, Ortega rips his right hand away. That's when McCarthy reaches out and pulls.
But on February 11th, he testified that Ortega reached up and grabbed his revolver.
In his deposition.
Right.
And Ortega, I'm sorry, McCarthy didn't say he grabbed his.
He said, quote, Ortega, quote, reached up and grabbed his revolver, unquote.
It was grabbed for his revolver. Grabbed for. He reached out and grabbed. There's two weapons: his primary weapon and his secondary weapon. The secondary weapon is on the ground.
And it's a revolver.
That's the revolver.
His primary weapon is a semi-automatic pistol, right?
He reached out and touched the revolver. He reached up as they were fighting. Once they got up and he was fighting, he reached up to grab the pistol, but he never got a hold of it. The only inference that he got a hold of the pistol was Karsh's statement. I'd like to reserve.
You want to reserve the rest of your time? Okay.
Thank you.
Good morning. May it please the court, my name is Christina Denning and I represent the Ortega family. First, I'd like to spend just one moment addressing the propriety of this interlocutory appeal. In all of the moving papers or the appellant's papers, Officer McCarthy construes the facts in the light most favorable to him, not the plaintiffs. The district court was correct in denying qualified immunity because plaintiffs have raised material issues of fact, so there's no reason for us to even be here. Assuming that we should be here, turning to the materiality of the facts as to the constitutional issues, And I think instead of recapping the law, because I understand that your honors are very familiar with the law, I will,
This is the third such case we've had in the last 2 days, and we've got one more right after. So you may assume
That's a good assumption.
that we're well familiar with the law of 1983 in these cases.
let me just then address some of counsel's points that he raised with specific references to the record. First, there's no evidence of any stippling or tattooing on the body of Victor Ortega that would even suggest that he was ever reaching for anything. The trajectory of bullets, which Judge Kristen, you've already addressed that, has Mr. Ortega in a flexed forward submissive position, and there's no indication.
Well, or
How does he get
collapsing.
shot in the stomach if he's in a flexed forward submissive position?
And I don't know if you want to, he's down towards the ground,
Right.
flexed forward.
Right.
But his head was not bowed down, so he was shot in the stomach because Officer McCarthy was about 4 feet behind, at least 4 feet, and that's another thing. Our expert puts him at least 3 to 4 feet.
But counsel, it would be consistent if Officer McCarthy were above the victim and the first shot goes into the abdomen, and then as the victim collapses forward, the second shot is to the back of the neck, right?
That's correct.
Except it only works if it's not a level shot, and Mr. McCarthy was above the victim, I think.
That's
That's the
correct.
only way I can make that make sense.
That's correct.
Okay, so if that's the case, then the inconsistency between the testimony and the physical evidence is the level of the shooting, who was up and who was down.
It's the level of the shooting, and we also have to note the grazing wound on the abdomen, because the first shot shows him, it's more proof that he was flexed forward, because he's lean, he's over 6 feet tall and 182 pounds, Mr. Ortega was. And the first wound grazes his stomach and then goes and enters in a downward position into his abdomen. Again, he's in a either kneeling, submissive position, most likely with his head up, or else it would have hit him in the face.
Well, I mean, to be neutral, I don't know that it's submissive. And I'm not sure that was the first shot. It's just the only thing I can make sense of this is that the abdomen shot must have been the first shot, and that the victim may have been as opposed to being submissive, he may have been collapsing forward, right?
Right, and it goes in a downward position, which shows that Officer McCarthy was on top of, or at least in a position superior, or however you want to describe
Well,
it.
it's just not level. He's higher, I think. That's the only way I can make sense of it. I mean, to be as neutral as possible on the factual evidence, it seems to me that that's the inconsistency, that the victim had to be lower than the officer.
That's correct.
Okay.
We also have evidence of handcuffs on both of the wrists of Mr. Ortega. We also have
What evidence is that?
the IME report. The autopsy report shows evidence of cuffs on both
Well,
wrists.
wasn't he cuffed afterwards by other officers?
According to Officer McCarthy, he's the only one that, and that leads me to.
But he was cuffed after he was shot.
After he was shot, isn't that standard procedure?
Correct. But there is, my
But
point.
that explains why there are cuff marks on both wrists. It doesn't tell us whether or not McCarthy only got one cuff on the left hand.
That's right.
So I guess what's the materiality of that argument?
The materiality is
factual.
that it's only Officer McCarthy that has this story, and we really have to, as Judge Parker had pointed out, we have to look at the changing stories of Officer McCarthy. And so, as part of the whole circumstance of the shooting.
I want to make sure I understand what you're arguing. Are you arguing that from these facts, the jury could conclude that McCarthy got handcuffs on both right and left wrists? Is that what you're saying?
Sure, I am.
Are you arguing that he was? What is the? You're arguing that he was shot when he was handcuffed?
At least one cuff, possibly two. We don't know. Officer McCarthy is the only eyewitness to the actual shooting.
Was there no testimony from any of the other responding officers that they cuffed, or did McCarthy say, I cuffed him after he was shot?
He said he cuffed him after he was shot, and then he had to move the body out of the corridor to administer
What he said is,
CPR.
I went over to Ortega and fully cuffed him after the shooting.
Right, and then the autopsy, or the scene photos will show that he only has one cuff on because he was then fully cuffed, then uncuffed.
Then uncuffed because they needed to administer medical.
Right, and this really isn't, the biggest point that I want to make about the handcuffs.
Well, it's the first time I'm hearing. I didn't see this in your brief, so,
And I also want to point out that not one witness, there are two people that claim to have seen part of the struggle. Nobody saw a gun. Nobody saw him reaching for a gun. So that begs the question, was there even ever a
didn't this all
secondary?
take place in a very narrow hallway or corridor?
It did, Your
So
Honor.
were the witnesses able to see both men from head to toe based on where they were vis-a-vis the position of the witnesses?
In terms of the depositions of Mr. LaRue and Ms. Marshall, they testified as to what they saw, and they specifically testified that they did not see anything lying on the ground. They had the vantage point.
Well, that's not my question. My question is, we know where they were, and we know where Ortega and McCarthy were, correct? So my question is, were they physically able to see from head to toe, if a person was standing, everything that would have occurred in that area?
And all I can say is I don't know, because
They weren't asked that on deposition?
they were asked, I specifically asked both of them what their vantage point was, and they could see in front of the officer. So Officer McCarthy at one point was on top of Mr. Ortega, and both of their heads at that point were facing the window across from where those individuals could see. So, I mean, without speculating, I would think that they had a clear shot.
Have photographs of the scene, or can we look and see whether or not there are railings or solid walls along this corridor?
They testified that they had a clear shot out the window and the door, and there are photographs in the record.
Okay.
But there are no obstacles.
Okay.
To being able to see. So my point is that they did not see a gun ever. We don't have any proof offered by anyone that there even ever was a secondary weapon on the ground. No one.
Recovered?
It was recovered. Officer McCarthy testified that he picked up the gun immediately after and reholstered it.
The secondary gun?
The secondary weapon. So we have nothing in the record other than Officer McCarthy's testimony that there even was a secondary weapon on the ground. We've got the 2 footsteps before the shooting with no sounds of wrestling, also as part of the evidence, and we have no DNA on the gun. All of these items of physical evidence and ear witness, eyewitness evidence contradict Officer McCarthy's story.
I thought there was DNA on the weapon, but it was inconclusive. It wasn't the same person, but they couldn't say whose it was.
Okay, so turning to the issue of the DNA, Officer Howie confirmed and he was the lead homicide detective for this investigation. He confirmed in his deposition that the DNA was not Mr. Ortega's.
That's not my question. The question was, were there DNA specimens that were taken off of the revolver from 2 different donors, even though they couldn't say conclusively whether or not it was Ortega's?
The second sample was inconsistent. They could not determine whose it was, but they ruled out the first sample as not being Mr. Ortega's.
I don't know. I mean, I'm not sure why you're having such a difficult time answering my question. My reading of that testimony in the report was that there were 2 samples detected and that they both did not come from the same donor. Is that correct or not?
That's correct.
But they couldn't conclusively say the second sample was Ortega?
Correct.
Okay, thank you.
You're welcome. As far as the inconsistencies that I want to address raised by counsel in terms of Officer McCarthy's own statements made, there are 4 key statements made by key time periods where Officer McCarthy gave his version of events. First, we have the briefing by Sergeant Karsh. We also have then the statement made after the shooting occurred and Officer McCarthy had an opportunity to meet with his attorney. Then we have his deposition, and then finally we have the declaration in support of the motion for summary judgment. There are numerous inconsistent statements regarding the use of the taser, whether or not Victor grabbed the secondary weapon, and
Or
also-
grabbed for it. even.
grabbed for it, and pointed it at Officer McCarthy. There's 3 different versions there. There's several different inconsistent statements about what Officer McCarthy did when Mr. Ortega allegedly tried to grab the weapon. At one point, he testifies that Officer McCarthy states or testifies that he blocked Mr. Ortega's hand. On another occasion, he said he swatted it away. On another occasion, he says he grabbed his right arm and threw him over to his side. And in another one, he says that he pushed it away. Those are 4 different movements. With respect to the briefing, I did want to raise one point about that, and in terms of the allegation that Officer McCarthy never made the statement to Sergeant Karsh. Sergeant Karsh is the supervising attorney or supervising officer for Officer McCarthy. And again, Sergeant Howie was the lead detective investigating this homicide. To this day, in response to Sergeant Howie's request that Sergeant Karsh supplement his report to clarify the discrepancy, whether or not there was a grabbing of the gun and pointing it at him, that statement's never been clarified. And that's
Specifically, which statement are you talking about has never been clarified?
okay. So turning to the record, it's the statement about grabbing the gun and pointing the secondary weapon at.
Right, but whether Officer Karsh made it, or I think Sergeant Karsh made an assumption, made a misstatement, whatever, on ER 98, Officer McCarthy is testifying, and they ask him, "What did Karsh ask you?" And he says, "I was telling him that, quote, we were fighting, and we were fighting over the gun." That's Officer McCarthy, right?
Right.
So what needs to be clarified?
What
They're
I'm
asking, when did you know he was not trying to get away? Answer, when he grabbed your revolver? Yes. When did he do that? When he reached to grab the revolver? This is Officer McCarthy.
the clarification that I'm discussing is Sergeant Howie, the investigating detective, had a problem with the briefing and what was said in the briefing, and asked that Sergeant Karsh go back and supplement his report. And in response to that, questions at Sergeant Howie's deposition as to whether or not he got or received a satisfactory answer to how that discrepancy is clarified, Sergeant Howie testifies that that is still an unresolved issue.
But Howie and Karsh weren't there. So we see cases all the time where well-meaning people get things wrong, make assumptions, all the time. But this is, so, which is why I'm really trying to focus on Officer McCarthy's statements plural, and whether there are internal inconsistencies and what Officer McCarthy said. And I think that was really going to Judge Parker's point, which is, I don't know that we need to go farther than that here.
I agree, Your Honor. There are numerous inconsistent statements about, and I can go on and on about the taser. At one part of his statement, he said that he's got one hand cuffed, puts the taser away, and then cuffs the other hand. At a different time, he says that he has both hands behind his back, and then puts and then reholsters the taser. Then, in his declaration in support of the motion for summary judgment, he completely omits the use of the taser. One other thing about the taser, and I see I'm almost out of time, is that Officer McCarthy, in his initial statement, said that he told Mr. Ortega to stop or I'll tase you. Not one witness ever heard anything of the sort. Another inconsistency between the evidence and his own statement.
Well, that's just an omission. They didn't hear it.
Right, that's the dog that didn't bark.
Yeah, okay.
All right, thank you very much.
Thank you.
I think I have a minute left.
You do.
I'll try to be very quick. As to the handcuffs, I think the court understood correctly. Okay. As to whether or not there was a weapon on the ground, Mr. Lohr didn't see the weapon, but he did see in the same sequence that McCarthy was talking about the fight and just before the shooting, he did see Mr. Ortega reach out and reach towards McCarthy's ankle, which is where the weapon was. So there's certainly some corroboration. In addition, after the secondary weapon was examined, there were scrape marks on it indicating it had come across the sidewalk.
So can you help me understand why there's appellate jurisdiction here? I mean, we've been spending the last half an hour vetting these various inconsistencies. I mean, they're legion.
Well, Your Honor, I think I would respectfully disagree.
Okay.
That legion, I'm not sure. I think there's an explanation. For instance, we were talking about Karsh. You call that a discrepancy, an inconsistency. Again,
You have responses to these inconsistencies, and you have theories about why how they occurred and so forth, but I don't see how that adds up to a version of facts construed in favor of the appellees.
well, I would say, Your Honor, that if you look at Cruz, he had a number of inconsistencies, and two of them were just blatant. One was no weapon. You know, why would he reach for it? The other was he's getting out of the car. According to the officers, he's standing up, takes the steps towards him, and then after they shoot him, they have to cut him out of the...
Could not have happened.
Right.
Okay.
These aren't those kinds of issues. These are cases that are much more nuanced and aren't the kind of consistencies/inconsistencies found in
Right,
Cruz.
which is why I think that's right. I think Cruz is a very extreme case, but this is a Cruz case.
It's a Cruz case, but
And that's why I go to the inconsistency that goes to the physical evidence about the shooting and the level and the trajectory. Because I think you're right, there's inconsistencies and there's material inconsistencies.
Correct.
Right.
And we're just suggesting that these are not material. And if one more thing about the DNA, I don't know if that's a critical...
I don't think it is.
All right.
I think I understand the record.
Okay,
Thank you very much. That case just argued is submitted.